Good morning, good afternoon, all the participants in this, I think, very exciting event. We welcome you all. We thank you very much. I'm sure a few others will still be joining us. It is really a matter of great pleasure for me. My name is Frans Viljoen. I'm the Director of the Center for Human Rights, if we've not met before. It's my great pleasure to welcome you and thank you really for deciding to spend the next hour or two with us in this exciting examination of the last year and how the African regional systems, bodies and mechanisms really fared on the basis of this report prepared by Amnesty International. I really take great pleasure in also noting with appreciation the partnership that we brought together for this event with the center. We obviously have Amnesty International, and then we have the African Court Coalition, the Initiative for Strategic Litigation in Africa, the Coalition for an Independence, the Independence of the African Commission, and the Initiative for Social and Economic Rights. We thank our partners. I think we all have the common objective of trying to enhance, improve, make as effective as possible the mechanisms that have been created under the African Union mechanism banner. So welcome once again. You'll forgive me if I also take a moment to note my pride. A number of the presenters here, whom we really thank also for their time from the various institutions, are actually graduates, alumni of the Center's Master's Program in Human Rights and Democratization in Africa. I acknowledge how far each of you have come, and I'm very glad to see you, in a sense, back here in our fold. Let me also maybe sign a note of nostalgia. Japheth and others obviously will remember the first of this series of reports being presented, being launched last year, more or less this time, and it was at that lovely hotel, Coco Ocean in Banjul. So I think we all feel a bit of nostalgia for having the sea breeze and the view of the Atlantic. That is not possible this year. But I think the point is the report has been done. It really deals with a very particular and challenging year, and we are here together to further examine the conclusions and look ultimately at how the African Commission, Court, and Committee on the Rights of the Child can meet their mandate. So thank you to everyone involved. Thanks to our technical team, Yolanda and Sampiwe at the center. Welcome everyone. I'm going to hand over to Osai Ojigho from Amnesty International, who will be the moderator for our event, and wishing us all good deliberations. Thank you.
Thank you so much, and welcome everyone. Good day, because I'm sure some people it's morning, afternoon, evening, wherever. One of the good benefits that has come out of the COVID pandemic is that we've been able to find creative ways to connect across different continents, different time zones, and to be able to be present to continue to share and engage. I have the unique honor and privilege to be able to bring this diverse group of experts on specific African Union instruments and mechanisms together in order for us to evaluate how far we've gone, what else needs to be done, and how each and every one of us have a role to play in this particular space. So the state of the African human rights system is one that has been a source of discussion, not only on the African continent, but elsewhere. And I think it will be very critical for us to see how we emerge from this conversation with concrete recommendations, as well as potential collaborations we can all have together. Before I invite my panelists, I would like to first of all, just remind everyone, by participating in this webinar, we have your consent to record as well as to live stream. It's live streaming as we speak on the Facebook pages of the Center for Human Rights. If you have any problems with having your face shown, as long as you're not a panelist, we would recommend that you turn your video off. We would be operating with basic rules of decorum. So please, all mics when you're not speaking.
Oui, Thérèse, comment tu vas?
Until you are.
Oui, d'accord. Oui, ça va. On rend grâce à Dieu.
So we would ask everyone to mute their mics when they are not speaking in order for us to be able to hear the speakers. And when it is time to open up for questions, we would give the opportunity for people to raise their hand using the raise their hand feature on Zoom or any other method that the host will be able to make available to us. Throughout the conversation, the chat box is open. You can drop questions and comments there, but we will not be opening the floor until after each of the panelists have spoken. For the panelists today, I have very broad speakers, and I would be giving each panelist 5 minutes to make their presentation. We will be taking questions after everyone would have given their presentations. So without much ado, I would like to invite our first speaker, my brother and colleague, Japheth Biegon. He's the Africa Regional Advocacy Coordinator for Amnesty International, and would like him to kickstart this conversation by presenting the findings of the research and what is the state of the African human rights system today. Japheth, over to you.
Thank you, Osai. It also gives me great pleasure to participate this morning, afternoon in this webinar. As Osai has indicated, my role really is to present key highlights of the Amnesty International's report on the state of African human rights bodies and mechanisms. The report was launched on 21st of October, the African Human Rights Day. It covers a 1-year period between 1st of July 2019 to 30th of June 2020. This annual report reviews the performance, the work, the achievements, the challenges of the African human rights system during that period. The aim of this project that we launched last year is to contribute to strengthening and reinforcing the regional human rights bodies, but also more importantly, to give visibility to the crucial role that they play in advancing the cause of human rights in Africa and providing a platform for vindicating the rights of victims of human rights violations and abuses. As an annual report, it's more likely to return a mixed bag of progress, achievements, challenges, and setbacks. And that is what really the report, as the inaugural one did show. This second edition also shows a similar pattern. In the overall, an overall finding is that the regional bodies did continue to face chronic lack of cooperation from states. But despite this particular challenge, the regional bodies excelled in several areas of their work, and in particular in standard setting and engagement with the various stakeholders in the system. They also took deliberate efforts to improve their efficiency and effectiveness, an element that is reflected in the introduction in all the 3 regional bodies of new rules of procedure that seeks to refine some of their working methods and processes. However, of course, our review shows that some areas revealed a stagnation at best, including or most prominently in the area of examination of communications or cases and state party. And perhaps that will be the first area where I would begin by showing the real work and performance during the year. Osai, would you please confirm that my screen can be seen? Thank you. So very quickly, let me begin with the question of determination of communications and cases. Our analysis, the report shows that the number of cases finalized remained relatively low during the last 1 year, but the pending cases, the backlog of cases before these bodies remained high. The African Commission on Human and People's Rights considered or finalized a total of 63 communications. And here, one important factor to note is that 36 cases, or 57% of all the cases that the African Commission were finalized during that period, were declared inadmissible. And this has an implication for us, civil society individuals who bring cases to the African Commission in terms of ensuring that the cases that we bring before these bodies meet the requirements under Article 56 of the African Charter. But it's also important to note that the majority, 83% of the cases that were declared inadmissible arose from similar set of facts and had been joined together for purposes of determination. We will remember that in last year's report, we saw that the majority of cases that had been struck out of the docket of the African Commission for lack of diligent prosecution by the complainants. But this year we see the rise of cases that have been declared inadmissible. The number of cases the African Commission decided on the merits remained very low. There was just an increase in one case from 3 in the previous period to 4 during this period. So the number of cases decided on the merits really remain very, very little in terms of numbers. One of the things that we sought to do this year was to determine the time allocated. I'm trying to move my screen, but it's not moving. Sorry about that. So anyway, maybe I should, for the sake of time, just proceed. Okay, good. One of the things we tried to do this year was to try to see the amount of time that the African Commission allocates to consideration of communications. And we tracked in the last 10 years how many communications are considered during each ordinary session and or each extraordinary session. And one trend that can be seen is that over that period of time, in the last 10 years or so, there's been reduction of the number of cases that are considered during both ordinary and extraordinary sessions. And we found that on average, in the last 5 years, the African Commission has considered an average of 17.5 cases during ordinary sessions and 31.6 cases during extraordinary session. In the early years, 2010, 2011, 2012, we saw there were a high number of cases being tabled for consideration. But I think it's important to note, and the report does note this, that most of those cases during 2010, 2011, and 2012 would be deferred to the next session without any meaningful consideration. So increasingly, the African Commission only tables the cases that it can actually review and consider during sessions. But the average really shows that there is perhaps need to increase time allocated for consideration of communications. And as we said last year, there seems to be an imbalance in the time allocated to promotional activities of the African Commission versus its protective mandate. The Children's Committee, our finding still reflects that it remains the most underutilized regional body within the African Union system. It received only 5 new communications, and it did not finalize any communication on the merits during that period. But it's also important to note that the lack of active use of the African Children's Committee could also relate to the lack of a bigger constituency of NGOs and individuals accessing and attending the sessions of the Children's Committee. We know that NGOs, more than 600 enjoy observer status before the African Commission, for instance, but not more than 20 enjoy similar observer status before the committee. So I think one of the calls of the report is for civil society NGOs that also are focused in Banjul to also turn their eyes and attention to the Children Committee and starting attending and actively engaging with the committee. The African Court, it's slightly difficult for me to move my presentations, but the African Court did deal with 46 decisions during the reporting period, 11 of which were on the merits. And it's important to note that some of the judgments that were issued on the merit were landmark judgments concerning, for instance, death penalty and the right to nationality. But the number of cases pending before the court also remains relatively high. I would like to focus now on the question of state reporting by the two regional bodies, the Commission and the Children's Committee. Because of the COVID-19 pandemic that led to the disruption of the sessions of the African Commission and the Committee and the Court also during the last half of the period that we examined, there was unusually low number of state reports reviewed by the two bodies. The African Commission reviewed only 2 reports of Chad and Zimbabwe, and the African Committee reviewed 1 report of Mauritania. Of course, in the subsequent period after the cutoff point, more reports have been reviewed both by the committee and the commission. But one of the things that we also sought to do this year was to analyze with a specific focus on the African Commission, how long it takes for it to adopt concluding observations after a state party report has been reviewed. And we found that on average, it takes the Commission 16.25 months, close to 17 months, to adopt concluding observations after the review of a state party report. And in the case of the DRC report, which was reviewed in 2017, it almost took 2 years before the concluding observations were adopted. Of course, there might be special circumstances that led to this delay, but generally there is a need to reduce the time between the adoption, the review of a state party report and the adoption of concluding observations. I will now wish to move to the question of states' commitment to the system and cooperation of states to these bodies. And the first measure of commitment really is ratification of human rights treaties. We examined the 7 core human rights treaties that the 3 regional bodies are mandated to supervise. And we found that the ratification rate stands at 54%. There are 385 ratifications that are needed for all the 7 human rights treaties to come into force and to be universally ratified across the continent by all AU member states. But as at the time of writing the report, there were 177 outstanding ratifications across the continent. But even more importantly, we found that the protocol on persons with disabilities has not been ratified even by a single state more than 2 years after adoption. And the protocol on older persons close to 5 years after adoption has only received 2 ratifications, and that is Benin and Lesotho. Then there was the question of state compliance with reporting obligations. We found that in the case of the African Charter on Human and People's Rights, only 6 states, as at the close of the reporting period, had complied fully with their reporting obligations, and that translates to 11%. 89% range from not complying at all, not ever submitting a report, to those that have 1 report overdue. We see that during this reporting period, one important thing that happened is that Cameroon submitted its state party report under the African Charter, the Maputo Protocol, but also for the first time under the Kampala Convention. So Cameroon becomes the first state to lodge its report under the Kampala Convention before the African Commission. This is a welcome development in the system, but it's noteworthy that it has taken 8 years since the Kampala Convention came to force in 2012 for a state party to report about its implementation of the convention. Then there is, of course, the question of urgent appeals that are sent by the committee and the commission to state parties. The African Commission did send out at least 14 urgent appeals to state parties. And what we found out is that only 4 of those received a response from state parties, translating to about 29% of responses. This is not different from the period last year where we found that only 31% of urgent appeals had been responded to. Then of course, we see that during the year, the backlash that we had witnessed in 2018 against the African Commission somehow diminished, but the focus seemed to have shifted to the African Court, where 2 states, Benin and 3 states, Benin, Cote d'Ivoire, and Tanzania, hit back at the court by withdrawing their Article 34.6 declaration for decisions or provisional measures that the African Court had issued. So that's one major political backlash that we see during the reporting period. Then finally, there is the question of funding and budget of the African Commission. As we said previously, the challenges, the performance, the work of these regional bodies must be seen in the light of the capacity challenges that they face. And that must be put into perspective. All the three regional bodies do not have adequate staff, do not have adequate premises or fit for purpose premises to operate from. But even more importantly, they do not have adequate finances. For the first time, I think, and this is a major development, the budget allocated to the African Children's Committee crossed the $1 million mark, and it received 121% increase in its budget, a development that is really welcomed. But we saw that the African Commission suffered a huge steep 14% reduction in its allocated budget, while the African Court suffered a 5% reduction in its budget. So essentially, they still remain largely underfunded and largely operating within very constrained capacity and workforce. I think, Osai, I will stop there. The report covers really a lot of issues, but I'm not able in these few minutes to cover all the issues that we cover in the report. Thank you so much.
Thank you so much, Japheth. I gave you some more minutes. You actually spent about 12 minutes going through your presentation, but since it forms the foundation of why this webinar was called in the first instance, I thought it was essential that people got the opportunity to be able to hear, even if it's short highlights of what the report is containing, especially for those who are yet to have read it. I think without much ado, we'll move on. You raised quite a number of issues, and I'm sure the co-panelists have taken note of specific reference to the institutions they represent. But I would like to invite Nkatha Murungi, who is the Assistant Director at the Center for Human Rights at the University of Pretoria, to take the floor next. Specifically, I would like Nkatha to also, if human rights is such a critical component of the African system, why does it appear that it's not being prioritized in our institutions? That would be something that I think would benefit from understanding what these challenges and the trends possibly could be. So Nkatha, you have the floor. Thank you.
Thank you very much, Osai, and thank you, Japheth. A good morning, good afternoon, good evening, colleagues, and welcome. I'll just pick up from where Japheth left, because some of the things that he has already mentioned is what I'll build on. And one of those is the fact that the report is very comprehensive. So really in 5 minutes or in 5 to 7 minutes, as I was told, I will not pretend to want to say so much. I also note the question from Osai, which I'll come back to at the end. So let me just start by saying I'm glad to, as I went through the report, to at least have a resource that brings together, that convenes a lot of the information that we look for within the African human rights system, and which was previously very difficult to find. So this report provides us with that tool, which is a very welcome addition. I would desist from making specific comments on the institutions because I am lucky to speak first, but the colleagues representing the various institutions will probably want to pick up on some of the specific issues related to the mechanisms themselves. So my reflection is more from a goals perspective of the report. And maybe I will be very choosy on some of the issues that I think we want to take forward, or just maybe have a discussion later on. The goal of the report, as Japheth indicated, was really to review and analyze the work and performance of these institutions from a working methods perspective, outputs, and impact. And I'm more interested on the impact side, because I think the working methods element is very well documented, but also, again, the representatives of the institutions here would probably have an opportunity and better knowledge to reflect on. So I do think that the report is very loyal to that purpose of indicating, and that of indicating what the processes and procedures and developments in that regard have been. And therefore it is quite content heavy as well as detail heavy, which is a good thing, depending on where you sit, it's a very good thing. I'm particularly interested in some very specific issues. I think when you speak about the impact, we need to be clear that it is basically in terms of the immediate impact of the actions and reactions of the mechanisms in the course of the year, because it's a very short period. So really not the longer term implications. But what I find useful and perhaps feasible to reflect within that time frame is in terms of maybe 4 issues that arise. And one of those is, one, I would say, political positioning that is inherent throughout the report, in as far as how the mechanisms, consider their role and respond to it. Then there is the question of internal capacity, so issues to do with effectiveness vis-a-vis the capacity, and some of the issues have already been mentioned, such as budgets and technical capacity at the Secretariat. I think there is also the question of the evolving context within which the mechanisms are operating. And I think that context has something to do with the linkages with the nature of stakeholders and even how stakeholders have been addressed in the report. I think I particularly maybe have a specific interest in that. And lastly, and closely related to that, I think is the role of CSOs. And I speak perhaps on the panel more from a CSO perspective. So please allow me to start with that element, because that is what I think I have a vested interest in from an institutional perspective. I understand, of course, that the report is focused on the working of the mechanisms themselves, but unless I missed it in detail, but I did try to go through the entire report, I don't necessarily see that the element or discussion in as far as the role of CSOs in the performance of this mandate. One of the things that I would want to put out there, even though there's a focus on the mechanisms and how they operate, there is often a tendency from role players in the human rights field to see the role of CSOs from the perspective of an outsider looking into the mechanisms. And I would want to see the perspective of the insider looking outward on how CSOs have contributed. How do the mechanisms view the contributions of CSOs, especially when you look at the bigger picture, where we are saying that the political context is not necessarily very favorable to the mechanisms. How are we as CSOs positioning ourselves to assist the mechanisms to deal with that? So in short, I think the element on CSOs, I would have wished that we have a little bit more, or that we redirect maybe some attention to it. The second thing I just wanted to speak to is, if I may go back again to the question of positioning and accountability. And I think I've heard from the presentation from Japheth, but also in the report, the reference to the ultimate goal of these mechanisms is to ensure accountability for human rights protection and promotion on the continent. And then there is of course, the climate within which they are operating, which is very obviously political. And I think there is a decidedly political undertone to the relationship that is existing between the mechanisms themselves, but especially between the human rights mechanisms and the other organs of the African Union. And I think that political undertone is also then overlaid by another, like a sort of a negative sentiment. So we are moving from the point of saying that there is a sense in which, that the political focus is negative towards the commission. It was the commission, now it's the court. We feel that negativity is thriving. I think I acknowledge it, and I feel that it is a challenge that we have to deal with. What I'm more conscious of in that regard is that I feel that it's natural that as the mechanisms strengthen and start to challenge states on implementation, that resistance will build. But I think that we might be too focused on or concentrated on the negative elements that arise from the climate, that we are not looking at the endemic structures that actually are political in nature, because these institutions are established within a political climate. So there has to be that will never go away. Perhaps we have to look at how do these institutions nevertheless operate effectively, even though the politics will not dissipate. And so that we are not too focused on or distracted from the purpose by the overall negativity, I think, which is periodic in my view. The final thing is on effectiveness as a defense against political pressure. And I think one of the things that is coming through and through is that the strengthening of the mechanisms And as the mechanisms strengthen, their purpose becomes more clearer, and their ability to, to speak to or to stand their ground against the other institutions of the political machinery is strengthened. But I think, the unfortunate cycle that if you're not delivering on your mandate, then you're not taking very seriously, then your credibility is eroded, then you don't get the resources, then you don't deliver. And I think what the foothold for political interference within the African human rights system has actually been the ineffectiveness. So this is, in my view, a question on how do we ensure that these institutions are tailored to accountability, which is the primary purpose. To what extent are these institutions also looking inward and spending more, investing more in their, being true or being very strictly loyal to their purpose according to the mandate as defined, as opposed to playing to the gallery or grandstanding against each other. That would really be, for me, a useful reflection to have. We don't have much time, and my time has sort of run out. I can see on Osai's face. I think one of the other, the final things that I will not discuss, but which I would just want to highlight in case we have time to come back to, is I think there are some specific issues arising from the report that perhaps if colleagues will not respond to, I would wish that we come back to. That is, for instance, the need to give context to some of the developments that are positive, such as the increased budget of the committee in the context of moving to Lesotho, which perhaps is event-based as opposed to strategic. I don't know, but perhaps we can come back to that, whether it's really a reflection of growth or whether it's a moment. The second thing is opportunities for harnessing, documenting, and transferring learnings of what is working within one institution to the other. What is the extent of collaboration and partnership and learning? That is really, I think, in a nutshell, and feeling, I don't know, Osai, if I have any more time, but I think I've tried to pack in quite a bit. I still have some other things that perhaps I can reflect on later on if we have the opportunity to. Thank you.
Yeah, thank you so much, Nkatha. As you were speaking, I was just noting down the nuggets of wisdom and insights that you are sharing. I'm sure there's a lot that we need to cover in this short time, but it's good that you are already teasing out some of these issues. And the other panelists, I'll ask you to build on this as well, even as our audience are also reflecting on what it is has been shared so far. Without much ado, I would like to invite the Acting Executive Secretary of the African Commission on Human and People's Rights, Lindiwe Khumalo, to please share our own thoughts and contributions to this conversation about the state of the African human rights system from the perspective of the African Commission on Human and People's Rights, which is also our oldest mechanism. So you have the floor. Thank you.
Thank you so much, Madam Moderator, and thank you to the Center and Amnesty International and all the partners for inviting the Commission to be part of this discussion. Arguably, the work that has been done is work that should have been done by the organs themselves, to the extent that it is reflective, it's evaluative, but nonetheless, it's an important outside voice that assists the organs to reflect on the work that they do and gain some independent insight into how the performance of the institutions forming the human rights system have been doing. And I would also like to say that it's a very timely discussion for the African Commission. Currently, we are working on our strategic plan for the next 4 years. And in this discussion, at the center of this discussion is the question of how we interact with member states, how we interact with the court, how we interact and intersect with the Children's Committee, and how we overall create value for the stakeholder that is the African citizen, but also member states of the Union. The report itself, my overall impression is that it captures aptly many of the key issues that the Commission itself has been grappling with at its level. Perhaps in certain aspects, perhaps we've been slightly unfairly judged, and I will point out, I will not be shy to point out also some of the achievements that I think that the Commission has recorded during the reporting period. But having said that, I'd like to pick up on a few issues, beginning with the one that Nkatha so rightly started with. And this is the question that of CSOs and other role players within the African Union architecture that may be useful for purposes of pushing forward the agenda of human rights. I am particularly looking at the role of the Pan-African Parliament and the ECOSOC in relation to the question, for instance, that is raised by the report regarding the pool of candidates from which the Commission is drawn. This has been raised as an important issue. Clearly, member states need to provide a bigger number of, or a larger number of candidates from which commissioners can be drawn in order to improve, of course, the selection process. But how do we do this? And to my mind, there is still a very important role for the Pan-African Parliament to be drawn into this discussion as a vector to establishing national level conversations around openness of the process of identification of candidates for the African Commission, but also for ECOSOC to the extent that it houses non-governmental organizations to do the same at member state level. I'm raising this because often when we talk about civil society, we're talking about civil society in general and often outside the ECOSOC. The ECOSOC has access, it has AU legitimacy, it has reach and voice that may be slightly differently placed, and perhaps they might have better access to the ear of member states with regard to some of the questions, simply because of their positioning within the union. With Parliament at member states level, they of course oversee the executive and may be an important vector to solicit in this venture. The second issue that I thought was important, given the short time that we have, is the issue of the staffing of the Commission. And I thought that it was important to reflect, as the report has, on the limited staff that the Commission has relative, for instance, to the court, relative even to the Children's Committee, both of which organs were established well after the Commission itself. And the question is, how can this be redressed? As a silver lining, and perhaps this is already in the public domain, the Executive Council in its recent mid-year session has taken a decision for the Banjul Commission to recruit its own critical staff. This is a shift forward and will assist to a great extent the Commission to mitigate its staffing challenges. But also, I think there's still great opportunity for other stakeholders, academic institutions, national human rights institutions, to begin to do something that I haven't quite seen in recent years with the Commission, but sabbaticals for their professionals to come to the Commission and augment the staffing capacity to move communications forward, but also for research in general. The processing of communications remains key, and I think that the report has been spot on in this regard. The processing of communications is a function of three factors to my mind. It's a function of time, the time that is available to both the Commission and the Secretariat to process communications. Secondly, it's a function of skill, the ability to draft communications and do so effectively within a short period of time. And then, of course, the numbers of staff. I would just like to pick up on one aspect of these three factors, and this is perhaps the issue of how the intercession period is used. Much focus is given to how the Commission uses its session time to process communications, but perhaps what happens during the intercession period and what is the level of engagement of both the Commission and the Secretariat during that period. I think that is where the answer will probably lie. And going into our strategic planning process, this is an area that we'll be looking at very critically with a view to finding solutions. I'd like to then touch on the issue of financial constraints. The report has been very clear. It is true that the Banjul Commission has had, this budget has been, marginally reduced relative to those of the other two organs that are being used as comparators. But again, I think it's also important to appreciate that when financial and budgetary decisions are being made at the level of member states, the ability of the organ to consume, the consumption capacity of the organ becomes critical. So that if the Commission is unable or is limited in its capacity to absorb those funds, but perhaps because staffing challenges and the ability to produce and to carry out activities, that can also be a challenge and a factor to be taken into account. Lastly, due to time, in the area of engagement with member states, I think across all the organs that are participating in this discussion, the question of how we can effectively engage with member states with a view to improving implementation of decision rates is a key issue. The traditional method of doing this is through press statements. It's through perhaps visits, country visits, and during which conversations take place between the Commission and member states. But to my mind, there is a big opportunity that is lost in going to the marketplace, if you will, of member states at the summit and engaging with member states on the margins of their own summit. This, I think, has not been an opportunity fully explored. At the AU summits, you'll have both heads of state that can be engaged in bilaterals, but you also have technical staff accompanying member states. And therefore, I think that that is an avenue that could be put in the pot of suggestions going forward for all organs. Of course, finally, perhaps the issue of the PRC subcommittee that is concerned with issues of human rights. This is a committee that has been set up indicative of some willingness of member states to engage in issues of human rights. And it's a platform that is so far underutilized and can be utilized. And the effectiveness of that platform is yet to be seen, but certainly it is one that we explore. Thank you very much.
Thank you so much. We have someone, can the participant mute? Good. Thank you so much for your presentation. And I also hear you in terms of some of the opportunities that we might not have explored. I particularly like the fact that the African Commission is going through a strategic review, and perhaps at some point during our conversation today, you can share what stage it's in and how people can engage and participate in that. I'm very mindful of the fact that we have 3 other speakers yet to speak. And so just to crave the indulgence of our audience and our hosts, that let's try to see how much of this we can give, because it's very crucial conversations are going to come out of these presentations. Grace Kakai, Head of Legal Division at the African Court on Human and People's Rights. Of course, we've also heard that the court has taken a big blow in terms of its, the fact that countries have withdrawn the Article 34.6 declaration, and so many other things are happening that would be useful to hear from your own perspective what exactly is going on and how can we stop this slide and what else needs to be done. So Grace, over to you. You need to unmute yourself, and please let's try to keep to the 5 to 7 minutes. Thank you.
Thank you, Madam Chair. Good morning, good afternoon, good evening to everybody present. We are very happy to be associated with this preparation of the report, as well as these discussions that the center and the other partners have decided to hold on this very important topic. So I have a presentation. I will just go and straight to the screen sharing so that we can move fast. Okay. I don't know whether you can see that.
Not yet.
Okay. Technical issues. Give me a minute. All right, can you see that now?
Yes, we can see your screen now.
All right, the brief was to prepare in reaction to the report, the achievements and challenges that the court has faced, and also to sort of react to what has been written in the report, just to indicate that we did provide information to Amnesty when they were preparing the report. So just as an overview, we'll cover the aspects of the achievements, major challenges and opportunities that we have identified for improvement, and then conclude. As has been mentioned, the court has faced quite a hit from member states who have withdrawn with Article 34.6 declarations, starting with Tanzania in late last year, followed by Benin in March this year, and then Cote d'Ivoire in April this year. So this has actually made it more urgent to review the methods of engagement that the court has with the member states. And then of course, the disruptive effects of the COVID-19, as we all know. But despite this, we have tried to forge ahead in terms of undertaking our mandate. Just to give you some statistics there on the court's work, because the focus of the report was really on the output of these organs. So just to give you an indication there on the status of the cases, the judgments issued, and orders on contentious matters, and then a graphical representation on the same. Just to point out that due to the COVID-19 pandemic, we had to suspend the first session of the year. So that has kind of impacted on our projected outputs for the year. And as at October 21, we had issued 18 judgments only, but we do hope to catch up on this with this session that we are currently having. And then again, the tabular presentation and graphical presentation on the advisory opinions issued. Not very many pending, only 2 are pending resolution. Then we now go to the major achievements. In addition to what has been provided in the report by Amnesty, because that covers up to end of June 2020, just to indicate that after that we had the 58th session, whereby we were able to deliver 7 judgments, 3 on merits and reparations, 3 on admissibility, and 1 standalone reparations judgment. And then also 13 orders, 7 on provisional measures, 2 on intervention, and 2 striking out applications and reopening. And then again, during this period, on 25 September 2020, the court adopted new rules of procedure. And then last month, mid-last month, the court's budget was passed by the policy organs, as indicated there, almost $12 million, with about 7.6 going to operational budget and 4.3 to program budget. Because in the Amnesty report, this issue has been indicated in terms of capacity. So we thought this is important to provide information to the audience here. Then we are currently holding the 3rd virtual session. The first was in June, and then September. This is the 3rd virtual session, and it's the 59th session. So pursuant to the practice directions on virtual sessions and electronic filing that the court adopted in June this year in reaction to the new working methods based on the COVID-19 pandemic. Now, the major challenges, I guess the focus of is on the finalization of cases, and we'd like to point out certain factors, both internal and external, which impact on how we execute that mandate. Just to point out that in terms of the judicial discretion on how cases are prioritized, we apply the first in, first out principle as much as possible. But there are other factors that come into play. For example, the subject matter of the application, the urgency of the issue at hand, among other factors. Then as previous speakers have pointed out, the issue of manpower. This remains a big challenge, and it's well known within the AU system, and the other organs can also relate to this fact. And we maintain that, we submit that the court can do more with increased human resources, particularly for the legal and the language unit staff, because both work closely, there are translation issues that have to be addressed and all that. An external factor is the parties. Parties request several extensions of time to file additional submissions, amend pleadings, etc. So the court usually grants these requests for the interest of the parties and to avoid proceeding in default, because that could also have an impact on compliance with the judgment. So this is an external factor. And then another issue that arises is requirements of translation. I think this is not really talked about much, but I think it's a very important issue. It remains a very important issue. And in the previous rules, the court had 2 working languages, English and French. But in the new rules, there are 4 working languages, Arabic, English, French, and Portuguese, as well as possibility for Spanish, I think. So this complicates matters. And in many cases, you have to translate pleadings, you have to translate supporting documents, and this can determine the pace of how the case moves. Just to give you an extreme example, in this application 028 of 2018 by Bernard Mona, filed against Benin and 7 other states. These are all the states that have filed the declaration. These states use 3 languages, and anytime any party applies for anything, extension, etc., that has to be translated, then notified to the other parties, who can file in any language they wish, and then you then in turn have to translate this. So this is a very good example of a case that, you know, the impact of translation on the proceedings. Another aspect is on requests for advisory opinions. People always ask, why do advisory opinions take a while to complete? But it's because default position is that requests for advisory opinions, all issues have to be translated into 4 languages, because these have to be sent out to the member states, because we have to get their opinion on all these legal issues that are presented to the court for an opinion. So that can drag the process out. And you know, as well, any requests that are made also have to be translated. And as I said, the shortfall, the minimal manpower we have in the translation, the language section, you know, really impacts a lot on how the cases proceed. Then the other issue is the budget cuts and moratoria on recruitments on short-term staff. This is a challenge across the board, but of course it does have an impact on the output of the court's work. So for example, again, there have been minimal increments in the budget for translation. Since 2018, it has fairly remained constant, yet the caseload is increasing and the requirements of translation are there. So this also impacts on the output. Another issue that is external is regarding the non-operationalization of the legal aid fund. Of the AU rather, it's for the 3 organs. And this fund would have helped us in providing deserving applicants representation so that they can file timely, their pleadings in a timely manner and in good quality, because sometimes making sense of applications filed by self-represented applicants can be quite a challenge. Now, how are we dealing with these issues? In the new rules of procedure, we have sought to address some of the challenges. For instance, we've introduced the requirement for filing applications using an application form, which is on the website. It's in all the languages, accompanied with a reparations fact sheet, because you're supposed to file your claim on merits together with the reparation submission. So we did prepare this fact sheet also on the website and in all languages to help, you know, whoever is filing the application to set out their claim in a more clear manner, so that we can be able to avoid situations of having to ask for missing information, required information, etc. Secondly, we are developing a manual on procedures before the court to assist parties, you know, familiarize themselves with the procedures and be more effective in prosecuting their case. We are also going to shortly disseminate a comparative study on reparations that we've done, covering the practice of about 17 international bodies. And this will be a public resource that we're going to post on the website. We will disseminate it through various networks, including the institutions represented here. So this is the objective is really to just ensure that people can follow the procedures and we get good quality pleadings, resulting in you know, faster disposition of the cases involved. Again, in Rule 44 of the rules, we have stricter requirements on compliance with timelines. And we hope that the court will enforce these provisions as strictly as the circumstances will allow, so that we can also shorten the time for consideration of cases. We have the pilot judgment procedure, where it will be an opportunity to deal with identical cases against one state in one judgment. And hopefully this is something that can deal with the backlog. Then Rule 67.3 of the rules requires the court itself to conclude deliberations within 2 sessions from the close of pleadings, so that we have, internally, we have that deadline on ourselves, and then the matters the judgments can be finalized. Then we also have provision for a broader framework on compliance with the decisions, where the parties will be allowed, you know, there'll be an opportunity for parties to follow up on this compliance. And then the court can also refer to credible sources in regard to compliance with the judgment, and then possibly hold hearings if necessary. And there's been the long-standing draft framework for monitoring decisions of the court that's supposed to be considered by the Executive Council. So the development on this is that the Technical Committee, STC on Justice, will be meeting on this later this month at expert level and then at ministerial level. So hopefully this will be finalized, because it's been pending for a while. And then we are also in the process of finalizing our strategic plan for 2021 to 2025. And all these issues that I have mentioned are also supposed to be addressed, enhancing judicial diplomacy with member states and others, enhancing knowledge management internally within the court, and then also developing tailored knowledge products for different stakeholders of the court to give them more information on how to engage with the court, utilize the court, and talk about the court. And then we leverage technology in all these processes. So these are the challenges which I believe are not peculiar to the court, but some are external, some are internal. And so long as it is at the court level, we will do everything that is possible to ensure the court delivers on its mandate, of course, with the support of member states and other stakeholders. And I thank you for your attention. Thank you, Madam Chair.
Thank you so much, Grace. Very extensive, very useful points. There are already questions in the chat, but as I said earlier, we would wait for all the presentations to end before we open up the floor. Interestingly, we have the African Committee of Experts on the Rights and Welfare of the Child represented here. And what I say interestingly, because oftentimes it's one mechanism that people do not know much about or are not engaging as such. Japheth had earlier highlighted that there are not many NGOs with observer status before this committee. But I think I'll give the floor to Ayalu Getachew, is a Senior Child Protection Officer, to also give us an insightful presentation on the mechanism and as well as any challenges that they might be undergoing as a result of capacity or resourcing. So you have the floor, and I hope I got your name right. Thank you very much. Please, let's keep to the time so that you can have some more time for interactions.
Okay, thank you, Osai. Thank you very much, colleagues. Good afternoon, good morning, and good evening. You are. Yes, as indicated, my name is Ayalu Getachew Asefa, and I'm from the African Committee of Experts on the Rights and Welfare of the Child, working at the Secretariat of the African Committee of Experts based here in Addis Ababa at the African Union Commission. So I'll go straight to the issues that I would like to highlight, considering the very limited time that we have, and I'm timing myself. I will try to reflect on some of the issues that that Japheth has raised, and of course included in the report, but beyond that, because I have discussed with Japheth, and I felt that there are some issues maybe missing in the report itself, which could be of your interest as participants here in this webinar. So just to set the context, and as the moderator has also highlighted, many people may not be aware of the system. We believe that the visibility of the committee is now somehow increasing, and this is also the fact that the committee has been invited to various forums of this nature is also a demonstration to that fact. The African Committee of Experts on the Rights and Welfare of the Child is one of the organs of the African Union, established to monitor the implementation of the African Charter on the Rights and Welfare of the Child, which was adopted in 1990, it came into force in 1999. So this year we are actually celebrating the 30th years of anniversary of the African Children's Charter. So particularly in November 29, we're just targeting the day where the Charter came into force. So starting from 23rd of November to 4th of December this year, as part of the 36th organization of the African Committee of Experts on the Rights and Welfare of the Child, we're going to have some activities in line with the commemoration of the 30th anniversary of the African Children's Charter, and you all are welcome to join that initiative. It is already announced on the African Committee of Experts website. Currently, the African Children's Charter has been ratified by 49 member states of the African Union. So we are only looking at 6 countries to ratify the African Children's Charter. These countries are DRC, Sahrawi Arab Republic, Somalia, South Sudan, Morocco and Tunisia. It has achieved almost a kind of a universal ratification, but we're still looking at 6 countries to ratify the African Children's Charter. The African Committee of Experts on the Right and Rule of the Child, the Secretariat of the committee is based here in Addis Ababa within the African Union Commission as part of the Department of Social Affairs. But currently we are in the process of relocation to Maseru, the Kingdom of Lesotho. So we will be hearing very soon, as we say the Banjul Commission, we're going to say the Maseru Committee very soon. So to be specific, the committee will be relocated on 9th of December this year to be based in Maseru for good. So that's this development within the African Committee of Experts is coming up with some opportunities, basically. Opportunities in a sense, as Japheth has mentioned and others have also mentioned, one of the challenges that we have with at the African Committee of Experts is limited staffing and human resource. Currently, the Secretariat has only 11 staff, 2 regular, 3 short-term, 5 seconded, and 1 intern, supported by the Center for Human Rights. But this movement will actually change the structure of the committee dramatically. So according to the decision of the Executive Council of the African Union, the Secretariat of the committee will be having around 46 staff. So of course, it's not going to be filled, of course, in 1 year time, but it's going to be filled gradually. But it will definitely address some of the issues that we are facing. One thing which could be of your interest and which in the future the reports can also engage more thoroughly would be the reservations that some member states have made on some of the provisions of the African Children's Charter, particularly the government of Botswana and Egypt. Botswana on Article 2 and Egypt on Article 44 and 45 of the African Children's Charter. And the committee has pronounced itself, saying that the reservations made by these 2 states against the provisions of the Charter is not in line with the very object and purpose of the African Children's Charter, so they should really consider withdrawing. And it's really affecting, particularly Egypt. The committee, of course, declared 2 cases against the government of Egypt inadmissible, but Egypt contested, saying that they cannot be sued before the African Committee of Experts because they have actually put a reservation on Article 44 and 45. This is basically about the communication mandate of the committee. So how can you actually, as a country, ratify Charter and submit a reservation or place a reservation on the procedural aspect of the Charter, on the monitoring aspect of the Charter? So, so we have around 4 countries placing reservation: Botswana, Sudan, Egypt, and Mauritania, which could be one area of investigation for future reports as well. In terms of state party reports, yes, the report has also highlighted a very important issue there. Out of the 49 ratifying countries currently, the committee has received at least 1 report, at least 1 initial report from 40 countries. So this is an encouraging trend, but it's not really enough. Because from these 40 countries, only 10 of them have actually submitted their periodic report. Cameroon, Kenya, Rwanda, Ethiopia, Burkina Faso, Tanzania, South Africa, Niger, Senegal, and Nigeria. These are the countries which have submitted their periodic report. So others, like among the 40 countries, they have just submitted their initial report and they just disappeared. So we've been trying to engage these governments to submit their reports. Out of these 10 countries, it's only Burkina Faso which has submitted its 2nd report. If you compare, if we have time, and if I show you a graph which compares actually submission of reports to the UN Committee, on the Rights of the Child and the African Children's Charter, you'd be surprised. There are countries which have actually submitted 6 reports and 5 reports to the UN Committee on the Rights of the Child, and then nothing to the African Committee of Experts on the Rights of the Child. And I'm talking about African countries. So these are issues really to engage with. What's the reason behind for countries to submit their reports duly to the UN, to the United Nations Committee on the Rights of the Child, which is a good thing, we're not objecting, but not to the African Committee of Experts. There are around 8 countries, and among them, most of them have actually submitted their reports to the UN Committee on the Rights of the Child. Countries like Libya, Mauritius, Cape Verde, Equatorial Guinea, Botswana, Central African Republic, Djibouti, and the Gambia. They've never submitted any report to the African Committee of Experts. But some of them, they have reported to the UN Committee on the Rights of the Child. During the reporting period, the committee received 2 periodic reports from Kenya and Ethiopia as well. And as Japheth indicated, the committee has considered the government of Mauritania's report, but Guinea-Bissau had to also be considered. But in terms of the delegation, the committee did not accept the delegation sent by the government of Guinea-Bissau because it was just a one-man delegation, which the committee, according to the committee's procedure, cannot be acceptable. So the committee had to actually return the delegation without considering the report. We do hope that the government of Guinea-Bissau will be sending its delegation during the 36th organization of the committee. So generally around the reporting procedure, there are issues that we have identified as major challenges. One is domestic budgeting for reporting is highly dependent on partners' funding. So governments do not actually allocate as part of their budgeting processes for reporting procedures. So if they have to hire consultants and if they have to procure consultancies, there are only few countries which have actually proper allocated budget line for reporting to treaty bodies and organs such as the African Committee of Experts and including the African Commission on Human and People's Rights. UNICEF's support on the ground, particularly on issues related to children's rights, is very crucial and significant. So we're working with UNICEF because UNICEF has been supporting countries to report to the UN Committee on the Rights of the Child. So that same support can also be extended to the African Committee of Experts, which can also address some of the issues. The time gap between preparation of reports and submission of the submission of those reports to the committee is very much concerning. And this could also be highlighted as one of the challenges that we have identified as part of our reporting procedures. Like, for instance, the government of Zimbabwe, we've been told that the government of Zimbabwe has finalized its reports way back, but it has never reached to our table. This is because one reason could be because of the long and bureaucratic validation procedures that governments have in terms of validation of reports, which are going to be submitted to treaty bodies and organs like ourselves. Quickly on issues related to fact-finding, investigations, missions, and follow-up missions. Yet the report tried to highlight some of them, but there are interesting developments as well and some concerns and gaps as well. The committee up until now has undertaken different fact-finding missions, investigation missions, follow-up missions to various countries, including Tanzania, South Sudan, DRC, Mauritania on issues related to children in slavery situation. During the reporting period, request for investigation has been made to the government of Eritrea on the situation of children in the Sawa military camp, which the government of Eritrea has responded, but not authorized the investigation. But same authorization request has been sent to the government of Sudan, DRC, Liberia, Namibia, which has never been responded. So you can identify this as one of the challenges, that governments are not really authorizing organs like the African Committee of Experts. And I'm sure the same challenge goes to the African Commission on Human and People's Rights as well, that they're not really responding to these organs and authorize missions, particularly when it relates to fact-finding and investigation missions. On communications, this is one of the most underutilized procedure within the African Committee of Experts. Since its establishment, 2001, and operation in 2002, the committee has received only 16 communications, 16. Of course, the committee has finalized 10 of them and 6 are pending. Among those 6 pending, 2 are in amicable settlement. 1 with the government of Malawi, and I'm sure Pacharo is here. He will be highlighting about the amicable settlement that we are having with the government of Malawi on a case submitted by IHRDA. Another amicable settlement is currently happening with the government of the Sudan on issues related to children affected by the armed conflict in South Kordofan and Blue Nile regions in the Sudan. During the reporting period, the committee has organized one communication hearing. This is a very interesting development within the African Committee of Experts, that the committee has actually developed guidelines for implementation of communications. So the committee, after issuing decisions on communications after 2 years, calls governments and applicants for a communication hearing. Provisional measures has been issued during the reporting period, and the committee joined 2 of the communications. So joinder of communications has also happened. So in the future, maybe the report can also highlight all these developments, because they can actually contribute for more research and academic engagements, but also institutional developments as well. Quickly, in 2 minutes, I'm going to skip my points on general comments, studies, and all those things. As part of the committee's mandate, the committee has been undertaking all these activities as well, and general comments particularly. The committee has recently, during its 35th organization, has adopted one general comment on Article 22 on issues related to children affected by armed conflict and generally in conflict situation. Establishment of special mechanisms within the committee. The committee has exactly 11 special rapporteurs, and recently has established 3 working groups: one on children's rights and business, and second, children's rights and climate change, third, working group on implementation of decisions and enforcement of decisions. So these are also very interesting developments within the African Committee of Experts for civil society organizations to engage with. Strategic engagement with other organs, including the Commission, Court, regional economic communities, national human rights institutes, and civil society organizations. With the Court and Commission and other organs of the African Union, we have a platform called the AGAP platform, the African Governance Architecture. So there is an engagement and collaboration, strategic collaboration with the other organs of the African Union mainly through that platform as well. And I have seen our colleague Ambassador Salah on the list. Maybe during the questions and answer sessions, he may also reflect on that. But particularly with the African Commission on Human and People's Rights, the committee has collaborated with the organ on specific activities. Like, for instance, the committee has developed a joint general comment with the African Commission on Human and People's Rights, joint letters of urgent appeals, for instance, to the government of Tanzania, if I'm not wrong, have been signed jointly with the African Commission on Human and People's Rights, which are also encouraging developments. There are engagements between the African Committee of Experts and regional economic communities, enhancing child rights protection architecture to be established within regional economic communities. And we're also working with regional economic communities on issues related to cross-border issues affecting children's rights. So these issues could also be included in the future as part of maybe the report. With the National Human Rights Institutes, we have just recently adopted guidelines on to grant affiliate status to National Human Rights Institutes. Civil society organizations, they are not 20, they are 34 organizations, still very low in number, but 34 organizations have been granted civil society observer status before the African Committee of Experts. One particular challenge, which could be highlighted here, could be the referral mechanism of communications from the Commission to the Court does not really include the African Committee of Experts. As you know, Article 5 of the Protocol of the African Court does not give the African Committee of Experts standing to directly access the court and bring cases before the African Court. There has been initiatives to amend the protocol, the Article 5 of the protocol, but it's a highly political process. It has been tabled before the Special Technical Committee on Justice and Legal Affairs, which requested the African Union Commission on International Law, AUCIL, to undertake a study on the legal implications of the amendment of this particular provision, and we're stuck there. So up until now, there is no referral mechanism between the committee and the African Court, which could also be worth engaging. Finally, more can be done to really for civil society organizations to engage the African Committee of Experts so that we can actually address particularly the very underutilized procedures within the African Committee of Experts, which relates particularly with the communication procedure. Thank you very much, and thank you. Sorry for taking 2 or 3 more minutes.
Thank you, Ayalu. I know you have so much to say, and thank you for bringing on board some of the things that we have missed in the study and also updating us on what is currently happening. I think this is a nice juncture to also, and we have the privilege of having a state representative from Malawi, and I like the fact that you already highlighted that, and for those who don't know, Malawi took the preemptive step to amend their constitution to raise the age of a child to 18, which is the international accepted standard. And it's crucial to see how do state parties also relate with the mechanisms and how they ensure that this involves some sort of exchange and understanding and mutual cooperation. And so I would like to give the floor to Pasharo Kaya, is the Chief State Advocate at the Ministry of Justice and Constitutional Affairs of the Republic of Malawi. Please, you have the floor, and let's try to keep it short and sweet. Thank you. Please unmute your mic.
It's okay now, right?
Yes, it's okay, great.
Okay, now thank you so much for this opportunity to engage with you and this star-studded panel. So many familiar faces, it's good to be here. I'll share 2 things. The report, of course, is very comprehensive. We can spend the whole day looking at it, but a very well done report, and congratulations to the team that came up with the report. But I'll talk on 2 things because of the 5-7 minutes issue. I'll talk about state party reporting, as well as the engagement of states with the 3 organs, the commission, the committee, and the court. Now on state, because of time, I'll go straight to suggest, to share my thoughts on what we can do going forward, some proposals for reform. So on state party reporting, I think it's clear that there's need for some sort of reform and creativity because, for example, the African Commission, the 2-year reporting period is too short. And then the reporting guidelines, which have been developed by the Commission, are quite demanding for us states. They are bulky and very demanding, such that if those guidelines were followed to the letter, we would literally have 500-page reports because they ask for a lot of stuff, a lot of information. You have to report on the charter itself and the protocol, and now we have added the Kampala Convention as well as the 2 coming protocols on disabilities and other persons. And then on top of that, we have so many guidelines and general comments, which also give us insights on how to compile the report. So it's just too much. So what I propose going forward is that 1, for us states, possibly we should be proposing the amendment of the charter so that the reporting period should be maybe moved to 4 years. It's something which Malawi has considered and will probably take it up with other stakeholders, but 2 years is just too short. Move it to 4, which is like the standard for the UN reporting system. Secondly, I think the commission and the committee need to work with states to develop a calendar of reports, of reporting, develop a calendar for reporting and other key events. For those countries which have not even reported, submitted a single report, maybe engaging them to find out what their problems are, what their issues are, and then working with them to say, okay, can we agree that maybe you're going to submit your report in 2022 and have the country commit that it's going to submit a report in 2022? This would be very useful. The calendar would also be good. The calendar, not only of state party reporting, but of events generally, would also be good, including sessions and other events. It would also be good for planning. I'll give you an example. As I sit here, I know next year when the UN treaty bodies are holding their sessions. I can easily plan to say, okay, Malawi is going to attend this session, Malawi is going to that session. It's not the same for our organs, for our institutions. We normally get a note of about maybe a month or so before the meeting. So at times planning is not good. So this calendar would really be good for our planning purposes, maybe a year-long calendar, so that we should know that we are meeting in Banjul in April. These days we are meeting in Malawi, for example, in October, November for these days. That would be very good. Number 3, there is need to use more interactive dialogue in terms of the review process, where by interactive dialogue, I mean that the report should be slimmer and more to the point rather than bulky and more involving, but then use the interactive dialogue during the review to get more information from the state and come up with almost immediate recommendations. We can look at how, for example, the UN bodies, of course, I know the UN bodies are more resourced and more experienced, but I think we can also find a way to catch up, use the more of constructive dialogue where the report is slimmer, but the dialogue facilitates a process where the country is engaged more to highlight its human rights issues, and the committee and the commission issue recommendations almost immediately. I think that issue has already been discussed about the delays in coming up with concluding observations. So we can use interactive dialogue a bit more rather than spend a lot of more effort in coming up with package reports. The other proposal I would give is that use a list of issues prior to reporting. This is something which has worked very well at the UN. So for Malawi, for example, I'll give one example, the Convention Against Torture. Our initial report on the Convention Against Torture was generated through the list of issues prior to reporting. This is where the committee or the commission would generate a list of issues on which a country would base its report. Now, if you look at those reports, you find that at times the reports, as I've said, they're packy. We talk about a lot of things, some of which are not even necessary. So if a list of issues prior to reporting was generated, we would zero in on the main issues. To say in Malawi, what are the issues now? Can you talk to us about issues to do with attacks on persons with albinism? Can you talk about issues of child marriage? So the report would zero in on the current and emerging human rights issues. That's something which the committee and the commission would want to look at. As I said, prior to the amendment, which as ISLA mentioned, tends to be a very long and political process. In the meantime, we can be creative and make the most of this opportunity for state party report. Now, let me go to the engagement with state parties of the institutions. There is, speaking from a state's perspective, quite a serious lack of awareness of the 3 regional bodies, especially in government circles. We should not take it for granted that these institutions are created by states, therefore states know what they're all about, but it would be surprising for you to note that most government ministries, government structures are aware of what these institutions actually do. I would think that there's more awareness about these institutions among civil society than the average government system. So we should not take that for granted. And then secondly, there's quite some confusion about the mandate of these institutions. Okay, we have the African Court, then we have the African Committee, then we have the African Commission. What exactly do they do? How are they related? That's something which we need to play out in terms of engagement. So in terms of proposals, we are saying that there is need for national focal points apart from the usual diplomatic ways of communicating between the states and these institutions. I'll give you an example of Malawi ourselves, which has worked very well. For the African Commission, the Minister of Justice, the Human Rights Section, is the national focal point for the African Commission, and to some extent the committee as well. Such that communication, when the commission is generating communication, it goes through our mission in Addis Ababa, it goes through foreign affairs, but the same communication is immediately sent to the national focal point. So we know exactly what we are required to do. Now, foreign affairs, our missions, they are busy with all sorts of things, and we should not take it for granted that each time they get communication, they act on it quickly. So it comes from Addis, has to go to foreign affairs, and it comes to the relevant ministry, justice or gender. That can be a month or 2 months down the line. So apart from the diplomatic ways, it would be good to establish national focal points so that the commission should know that if we want to talk about commission issues in Malawi, we get to this ministry. The committee would know that, okay, Malawi's report is overdue. Who do we get in touch? The note of Eba can take time to fly between Addis to Lilongwe, but the direct communication with national focal points would be very helpful. And that has also worked very well in the UPR system, the United Nations Universal Periodic Review system, where the UN has actually worked with states to have national focal points on UPR, and the communication there works very well. So how do we increase awareness? Number one, using cases, current cases to increase awareness. And the perfect example is what ISLA mentioned about Malawi and the amicable settlement. We have had one case before the committee, IHRDA versus Malawi, and this was amicably settled when we amended the constitution to raise the age of the child. But what that case did was really to amplify the awareness of the committee in Malawi. Civil society, government systems, parliament came to aware of it. The office of the president came to know about it. So prevailing cases which have been filed against countries can be used as a route to amplify to raise awareness of the institutions in various countries. So for us, only one case, but it has, before that case, very few people knew about the committee. But after that case, there's huge awareness, even from civil society organizations. It's a success story. So it's something which we repeat over and over again at every opportunity. And that has really raised the awareness of the committee. The second point, of course, Article 34.6 is also a great way of raising awareness. I think Malawi is one of the few countries, fortunately, which made that declaration. And we have had several cases with the court. And the general awareness of the court in Malawi is pretty high, although it's not as high as we would have loved it to be. Number three, in-country events, apart from the usual meetings we have in Arusha, in Gambia, or in Addis, events being held in countries, various countries, would really help to raise the awareness of these institutions. I'll give an example of a few years back when the African Court held an awareness meeting in Malawi, which was actually opened by the then president. And I remember one of the things he mentioned at that time, this was pre-Malabo Protocol days. He mentioned something about the need for Africa to create its own court, something like that. So what that event did was to raise the profile of the court to the highest level in Malawi and increase awareness of the court. Lastly, let me talk a bit about the political backlash and pressure, which I think the Commission and the court have suffered in the last few years. Now, the states feel at times that the regional bodies, like the Commission and the court, I don't know much about the committee, have been captured, I'm using the word absolutely loosely, by civil society interests. Yeah, I can see Osai the way you are broadly smiling. Yeah, using it loosely. Yeah, so there is that feeling amongst us to say, no, I think the commission has shifted from its original, you know, when we were framing up the charter, this is what we had in our mind, that the commission should be like this. This is what we thought the court should be like this, but it has swung this way. It's now serving the interests of civil society. I just wanted to mention that because that's a real feeling. So we have to deal with it and find a way of handling it. It's a perception. It may be true, may not be true, but it's something which is in there and we need to discuss. And the very, very last, we need to be sharing success stories. I'm sure all our three institutions have grown immensely. I think what is coming out, the quality of everything that is coming out from these courts, from these institutions is amazing. I've been in the midst of justice for quite a while. I've literally seen the African Commission grow before our very eyes. The committee itself grow, the court. So it's something which we really need to be proud of, and we really need to support these institutions and share the success stories amongst ourselves. And we states now, we need to link the various activities of the regional bodies, or the various mandates to the national initiatives. So I've given an example here of the human rights action plans, our domestic human rights action plans. For example, our draft human rights action plans spells out how Malawi will be relating to the African Commission, how Malawi will be relating to the committee, how Malawi will be relating to the African Court. And then, for example, sectoral plans and strategic plans, for example, Ministry of Justice. Our strategic plan, which expires next year, has a target to say by 2021, we should clear all our state party backlog, state party reporting backlog. So you see, this is a domestic initiative, but it is linked to what we are required to do at regional level. And very, very lastly, I mentioned something about why countries are more excited to submit to the UN and rather than to the African system. That's very true. CEDAW reports, I mean, for Malawi, we took forever to report on the African Charter, but CEDAW report, we were reporting from day one. CRC, we are always on time. The reason is, I think he mentioned something also about these UN agencies like UN Women, UNICEF, UNFPA, normally support the state pardoning processes. There's no such support at the African level. So countries feel it's easier that way to run where there's already support. But what we did something clever, I would say, because when we were submitting our ICCPR report, we got support from UNDP, and we used the same data and the consultative process to draft a report on the African Charter. And when we were doing a report on the CRC a few years ago, we used the same data to the entire process funded by UNICEF to do a report under the African Charter on the Rights and Welfare of the Child. That's how our initial report was born. So I think states simply need to be creative. If the UNICEF comes to you and says, okay, we have money for CRC, you look around and say, okay, CRC, when is our African Charter on the Rights and Welfare of the Child report due? It's within around the same time. For example, we are right now, Malawi is supposed to be submitting our report under the African Charter on the Rights and Welfare of the Child. And CRC is due in 2 years. Then ICCPR is due in 2 years. At the same time, we'll be supposed to be reporting on the African Charter. You use the same information and the same resources. So briefly, I may have eaten 1 or 2 more minutes, but that's what I can share. Otherwise, the report is great and makes a good reading. We can be here the whole day. I hope the next report will do it again at Coco Beach Ocean or Kairaba or somewhere there. Thank you so much.
Thank you very much for that, and also for contributing to answering some of the questions that have already been highlighted in our chat. I would like to say that we are quickly running out of time. I think we have just about 16 minutes left for this webinar, but they've been very insightful comments as well as insights provided by the panelists. And I just want to quickly just highlight that in 3 issues. So one is there's clearly a need for better sharing of information and interlinkages between the institutes themselves, civil society, as well as the political leadership at state and at AU level. This issue about national focal points have come up again in terms of how do they interact with the institutions and what role can they play in streamlining some of these demands for compliance and reporting and execution that we are seeing that is deficient in our system. And finally, we need to look at a clearer role for civil society. There were also suggestions, this came from with regards to the role of the Pan-African Parliament and ECOSOC and how this can lead to better openness and transparency. The issue of state reporting, it seems to be something we're hammering on, whether we're reporting to the UN or reporting to the African Union institutions. There seems to be a gap in terms of compliance. And so we've gotten some feedback that the UN mechanisms have the resources, have the staff, have the various agencies that are focusing on particular charters, particular treaties that are then able to support the development of these reports at national level, which are then submitted to these bodies. So perhaps this call that that there should be some sort of calendar or coordination would be useful. While we were in this conversation, I saw that Ambassador Salah Hamad, head of the AGA Secretariat, was on the call. I don't know whether he's still on the call. And I know that there was a time when AGA was looking at the possibility of harmonizing some of this reporting and providing support from AGA in terms of improving African countries' compliance to African instruments. Also, there have been various engagements by civil society, whether it's the Coalition for an Effective African Court, the State of the Union Coalition, and various bodies at different times to see how they engage and strengthen the reporting as well as compliance within national borders. So with the few minutes we have left, I would first of all want to thank our panelists, but they are not let off soon. There are some questions that are majority of it are directed at Grace and the African Court. And then there are some others for the African Commission and some a bit more general. So I would like to, first of all, read out the questions specifically for Grace, if Grace could note it, then also the ones specifically directed to Lindiwe, and then the ones that are general to just direct it to one of the other co-panelists if they could take a shot at responding to that. And hopefully we'll be able to complete that in 15 minutes so that we can close off this session. I would like to also thank our participants who have been very active. I noticed that at the height of our conversations, we had 187 participants. So we have about 165 now, but I'll say please hang in there. The conversations are still ongoing and you might get a response to your questions now. So for Grace, you have quite a lot, but I'll try to highlight the ones that you could respond to quite quickly. So one question was with regards to I think it was Lucy, regards to the Article 34.6 declaration.
Sorry, Madam Chair. Sorry to interrupt you. I've noted all the questions. I was checking the chat box, maybe to save time to answer them. If you're giving me the floor.
Yes, I would like to give you the floor if you've noted the question. After you, Madam Lindiwe, because there were also 2 specific questions to her in the chat. Thank you very much, Grace.
All right. Yeah, there's a question here about Africanizing our institutions. Just to point out that under Rule 27 of the rules, Swahili is an official language of the court, but it's not a working language, but it is an official language. And also any other African language is considered a working language, of an official language of the court, sorry. Then Lucy has asked about the reparations process. And specifically about the Ojigho case that is pending. Just to highlight that we had tried to fix the hearing on this matter in March this year, but because of just an issue of scheduling between the parties, I think it was a space of a week or so, they could not come to an agreement on a suitable date, rather, for the hearing. So we then postponed it, and then COVID happened. And since then, we have attempted to have a virtual hearing. I think we explored this option in September, but that did not work. And then again for this session, but it did not work. And then we decided, because of the complexity of the matter and possible hearing of witnesses, it would be better to have an actual physical hearing rather than a virtual one. So we are looking at having this in March. I know that delay is quite lengthy, but in the circumstances, this is the best we can do. In regard to close of pleadings and the deliberations, well, when the pleadings are closed for the written procedure, and if you have a hearing, you would have to wait for the hearing to be concluded before you now start the deliberations for the time to start running as regards preparation of the judgment. So once the hearing is held in that case, then the deliberations will start, and hopefully that judgment will be delivered within 2 sessions after the end of the hearing. I also want to point Lucy out to Rule 93.1 on the issue of compliance of the judgment. I guess you're talking about the judgment on the merits of this matter. Perhaps this is something that is still debatable as to whether Rule 81 would apply to a situation of a judgment that was concluded under the former rules. It's still up for interpretation, so I do not want to say anything that would preempt that position. There's a question here about mechanisms to enforce judgments. Well, the court actually noted that, just to indicate that only Burkina Faso has fully complied with the judgments of the court. Out of the almost 50 or so judgments, about 45 judgments that require reporting, only Burkina Faso has fully complied, and the rest has been part compliance or no compliance at all. So in regard to this problem, that is why the court decided to have a more involved approach in the monitoring of the compliance with the decisions, and thus Rule 81 was included in the new rules. And then along with that, we now collaborate with the Executive Council in its role of monitoring execution of judgments and the other decisions, not only judgments, even provisional measures by the states concerned. So as I indicated, that is supposed to be considered at the end of this month by the policy organs. Now, the civil society also have a very important role to play in terms of the compliance. As I indicated, the court can get reports from credible sources to assess compliance with the decisions. So this is an opportunity for civil society to get involved at that stage, because when the court delivers a judgment, we have started a practice of having judgment summaries so that this can be publicized in the media, and the media have taken this up. So this is normally written about in the media, and we disseminate it through various networks, the judgment. So once that is out there in the public, the civil society organizations in that area or generally can be involved in even providing these reports. I don't want to use the term alternative reports, but they can provide these reports that to supplement what the respondent or the applicant would provide. So this is a very important role. Again, because the court considered this matter and saw the need to engage more with states, enhance that judicial diplomacy, we had planned to have an international conference on implementation of judgments with all the member states, not only the ones that are states party to the protocol, but all member states, just to explain to them what is the nature of the decision, because some of them feel as if that subsidiarity is not being respected or something of that nature. And also just to explain to them the process of the court. But because of COVID issues, that could not happen because that budget had to be reallocated to something else. There's a question here about what can be done to stop withdrawals. I think if you check the Ingabire Victoire versus Rwanda decision on the withdrawal, the court actually affirmed that the withdrawal is within the prerogative of the state, just as the filing of the declaration is within the prerogative of the state. And then it simply sets the time when it will take effect. So of course, you try to avoid a situation where you will get to the withdrawal, but that is why we are saying, let us have enhanced judicial diplomacy to explain to them the nature of the relationship between the court and those states, and also indicate that the decisions of the court are not supposed to, they are not envisaged to take away from the decisions of the national, from the status of the national courts. Those 4 states that have withdrawn their declarations, they all indicated that they are withdrawing them and they would study the matter further with a view to resubmitting them. So we are saying that we want to engage with those states to finalize this process that they're undertaking and resubmit their declarations. And also the civil society support on this would be very, very important in terms of following up with the concerned agencies. Focal points, Mr. Pachiro explained that Malawi has a focal point. Indeed, the Malawi communicated to us their focal point, so which is something we appreciated, and it facilitates communication with the court on the few matters that have been filed against Malawi. Then to respond to the issue of states not knowing, they create this institution, but they might not necessarily know, how they operate. I guess maybe because of turnover in the concerned ministries or for some other reason. Because of this, the court has decided to, as I mentioned, develop tailored knowledge products. If it's for civil society, for lay persons, for state representatives, diplomats, etc., so that they can know what is it about, what is my role in that process, because people have different interests in these processes. Then lastly, Lloyd and Chan have asked about this issue of collaboration between the commission and the court. Well, this is something that has been in discussions for many, many years. And we hope that with the new rules of procedure of both institutions, this will give us a framework to enhance really and just give that provision in the protocol on complementarity between our 2 institutions life, so that we can have, we can realize this aspect of complementarity. And I think, if I'm not mistaken, Madam Kumalo would correct me, but I think the commission would probably be considering issues under non-compliance with its own recommendations as a submission under Article 1 of the Charter. But we're looking forward to receiving those communications at the court, and we're ready to consider them. That was the penultimate question. The last question is about private sector funding. At the cost level, the concern here is about whether this would affect the independence of the court. So in that regard, the member states actually decided that the court would be funded 100% by member states, just to kind of guard against this kind of influences. But in view of the fact that they have not yet made good on that commitment, they have, I think, adopted a decision to defer implementation of this decision for, I think 2 or 3 years. So far we are allowed to accept funding from non-member states, mostly for the program budget. Yeah, this is what I hope I didn't miss. I hope I did not miss any question. As regards the budget, that why does the court get more funding than the commission, yet it has been there longer? I don't know, I guess maybe it is because of the issue of that Madam Kumalo mentioned. The budget is based on your previous budgets. So if your previous budget was lower, there's really not much room to maneuver, I guess, unless you're undertaking a major project, for example, like what ISLA has said, that they are moving the seat of the committee from Addis to Maseru. That would result in a high a very big increase in the budget. So there's that, the baseline, I guess that is how I could explain it. The baseline for the court since its establishment was quite high, and we have continued building on that because the sessions of the court have been increased from 2 to 3 to 4 weeks. So the budget has been growing. And because they take that as a baseline, I guess that is what has resulted in that disparity. Perhaps the baseline for the commission has always been lower than the court anyway. So these are my responses to the questions posed. Thank you, Madam Chair.
Thanks very much, Grace, for responding to those questions. Because of time, I would like to move to Lindiwe and to ask her to respond to questions that were directly directed to her, and also to conclude with one word or one sentence. Thank you.
Well, thank you. I'll start with the question that Grace has just touched on, which is the issue of the budget. The question from the participant seems to ask the question, is the funding of the commission a function of the unwillingness of member states to fund an institution that, by comparison is the older of the group? And I think that we can conclude that there's little evidence to show that it's as a result of lack of willingness of member states to fund. It's an issue of the structure of the commission and its ability, the commission's ability to use the budget that is given to it. Just to illustrate, if member states gave the commission today double or triple its current budget, the commission would not be able to use it. One, because it does not have the human resources to produce, to convert that money into products. It does not have the research capacity, it doesn't have the analytical capacity to do the work, the drafting capacity because of numbers of staff, and the structure itself does not allow it. So the second element of the question, as I understand it, is the structure of the commission or the inability of the commission to absorb more budget, its own failure to place a demand on member states for, say, a bigger structure, or is it that member states, have withheld? My response to this is that there is an opportunity for the commission to initiate a process to grow its institution, to grow the number of staff that are allocated to the commission, to grow the different portfolios that are within the structure of the commission. The commission can initiate that process. And part of the strategic planning discussions that we'll be having in this 67th ordinary session will be around how to do that, how to develop a structure that is significant enough to demand, to be able to demand a bigger budget. For now, it's just not possible. Actually, if you look at the past 3 years, the commission has returned money to Addis. So it's not an issue of member states, it's actually on this end of the state. Having said that, there is, of course, an institutional reform process that has been initiated by member states that is aimed at looking at the commission, the court, and the Pan-African Parliament. And we are looking forward to this process as an opportunity to make a business case for the growth of the commission structure, and therefore its budget, and therefore its capacity, and therefore its ability to execute its mandate. So that's the one question. The second question related to the rules of procedure and what had motivated the commission to amend its rules of procedure. Well, the short answer is the commission sought to seek an opportunity to improve its working methods and thereby produce better results. So for instance, the one element that is highlighted in the report, that of administrative seizures, transferring the decision-making of seizures of communications from the Commission to the Secretariat. This way, it creates speed in the process because the decisions on seizure are now determined by the Secretariat during the intercession period. There's speed involved, and we move away from the laborious process of engaging the entire Commission on an issue such as seizure. Finally, my parting shot is basically just to build on what Malawi has said regarding the need for engagement by all the organs, including the Commission, with member states. I think it's a pressing need. Malawi has been very clear, and I think Malawi speaks for all member states in saying the key architects of any of these bodies were member states, and they had a vision in mind and expected at the end of the day to be better supported to implement the charter at member state level. So, to the extent that member states see themselves as the primary beneficiary, of any of the resources, advisory opinions, and so on, they expect to see support, and they measure support from these different organs by the quality of advice that they get, the quality of support that they get. So I am personally very appreciative for the feedback that we have received during this session. It's certainly something that I will take with me into the discussions of our strategic planning. And I thank you very much for the invitation.
Thank you very much too. So I would like to also give the opportunity for final words to Ayalu, you are next, and then to Nkatha, Mr. Pachero, if he's still around, and then Japheth.
Thank you, Osai. Thank you very much, colleagues. I don't think that I have many questions directed to me. I have noted the private message that participants have sent me, and some of you, I have actually responded already to your emails, to the emails that you have left. So I think, so I don't have to share those responses here. There is just one question about South Africa and what the committee is doing to ensure compliance with member states with regard to reporting to the African Committee of Experts on the Right and Rule of the Child. Only to South Africa, but to all other countries which are not respecting the reporting timelines. As an organ of the African Union, together with other organs of the African Union, the committee reports to the Executive Council of the Union. Through its activity reports, the committee always highlight which countries are submitting their reports and which are not complying with their reporting obligations, so that we get some kind of political push from the Executive Council, really lobbying countries to comply with their reporting obligations. And the reports, something that we might have to also bear in mind, of course, I'm preaching to the converted, and most of us here would understand the benefit of reporting, but sometimes the word reporting might give a very wrong impression, saying that some people might understand that it's just a report. So it's not just a report. It's only through these reports that the African Committee of Experts and even the Banjul Commission can actually engage governments, so that we know what's happening on the ground. Because the African Union and its organs, they are not based on in many countries. It's only through the reports that the committee receives from member states and from state parties particularly, that it can understand what's happening, what are the opportunities, what are the gaps, and what are the challenges, and what can be done to improve the lived realities of children on the ground. So it can also provide opportunities for countries to learn from others. The reporting procedure, the reporting consideration procedure is open to all. So it's done in an open session. So other countries can attend those reporting consideration sessions where they can actually learn from other countries what's happening with regard to protection and promotion of children's rights in their in other countries. So it provides a lot of opportunities for countries to learn from each other, and also for the African Committee of Experts to understand what's happening on the ground, so that we can issue concluding observations and recommendations accordingly, which could actually guide member states to implement children's rights on the ground in a better way. So not only through the Executive Council, but we also write notables, continuous notables to governments to comply with their reporting obligations. We organize different forums, various forums, where we bring countries which are duly submitting their reports and countries which have never submitted reports together, so that they can actually share experiences and things like that. So there are a number of ways where we engage member states which are not complying with the reporting obligations. And finally, I would like to say thank you on behalf of the African Committee of Experts, and particularly the Secretariat of the African Committee of Experts, for being invited for this to this forum, and Center for Human Rights for organizing this, and of course assisting the African Committee of Experts, not in many other ways as well, and Amnesty International for taking the lead on production of this important report as well. Thank you very much.
Thank you. Parting words, not last words, parting words from Nkatha.
Thank you, Osai. I will be quite brief, just for, because it's a final word. I think for me, my parting point is that in all this process, and even as we think through the successes and the gaps and the opportunities, I think it's important to keep in mind that the ultimate client of all these mechanisms and the goal is actually the African citizen on the ground. It's so if we keep our minds on that, then you have perspective about everything else, about the political positioning, about the strategies, and trying to clarify and justify our various existence and processes. I think let's keep in mind that ultimately, the ultimate client is African citizens. And closely tied to that, I think the biggest takeaway from here, each of the mechanisms recognizes, and I think we want to make it clear again, that there is really need to bridge and make relevance with, or rather give relevance of these institutions to the regular person on the African street, so they would own it from that point. Then the rest of these challenges that arise in terms of funding and political challenges and all that would really, I think, significantly be lessened, and the purpose would be amplified. Thank you very much. Thank you to Amnesty and to colleagues here. It's been a pleasure, and hope to continue engaging beyond. Thank you.
Thank you. Mr. Kaira.
Okay, thank you so much. To all of you, as I said in my presentation, very good report and very rich. But as you are saying the word, I was wondering how much this report has been disseminated, especially to states parties. I think as states, we need to know, because there are quite a good number of recommendations to states here. So we really need to know what is going on and what we need to do. I was actually reflecting and wondering how many participants are from states parties in this webinar. It would be good to find out, but no, good work. We still have more work to do. And as I said, our organizations have grown tremendously, and there's a lot of pride that we need to have for this, but there's still room for a lot of improvement. Great work being done, but I think we can, working together, achieve more. And as the previous speaker was saying, ultimately, it's the African citizen. It's a woman, it's the child in our villages who should be the beneficiary of these institutions. So thank you so much, and looking forward to more of such exchanges. Thank you.
Thank you too. Japheth.
Thank you, Osai. I think mine is just to reiterate what Pacharo has said. I think what our report shows is the tremendous growth of these institutions from their inceptions to now. And the report, as this discussion today has shown, really contributes to reflections amongst the bodies, but amongst all other relevant stakeholders on how these bodies can continue to be reinforced, continue to be strengthened, and to be more effective and efficient in the execution of their mandate. I'm really happy and grateful, and I think perhaps Osai, you'll be the one to do this, but grateful to the 3 regional bodies for the support that they have given us through the writing process and the embrace that they have given to the report. We look forward to continuing engagement with future editions of this report, and we take the certain elements and issues that have been raised here in terms of improving the report, and also in terms of sharing the report directly to state parties. We'll be doing so in this edition, but also in future editions. And also, you might have realized we do not have the French version of the report. It will be coming out and shared on 16th of this November. But in future editions, we'll ensure that we have the French version on the same day that the English version is launched. But thank you so much, Lindewe, Ayeleu, Kakai, and Nkatha for the really candid, critical reflections that we've had this afternoon, morning. Thank you so much, Osai.
So on that note, I want to thank everyone again, individually and collectively. The time you spent here shows your commitment to improving and strengthening the African human rights system. We don't take it for granted. We appreciate each and every one of you. And on behalf of the hosts and organizers of this particular webinar, we want to thank you all, and also that whatever has been shared here would be used to improve our work collectively, as well as to also show us how we can work better together. So thank you very much. Please do enjoy the rest of your day, and we hope to have another opportunity where we can reflect, share, and even show an improvement on what we have gained from participating in this protest and participating in this process. So thank you all so much.
Thank you.
Thank you.
Thank you, bye.
Thank you, so bye.
Thank you.
Bye.